Yes, it's my pleasure to introduce Dr. Michael Lambert, or Mike, as he's let us know we can call him today. Will be joining. Has joined us, and he's about to give us a talk, which is entitled "On the Record or Off the Case: Archival Sources of Forced Adoption by the British Welfare State." In this talk, Mike will be looking at the growing recognition that adoption was far from consensual throughout the classic era from the 1940s to the 1970s, where thousands of children were taken from their unmarried mothers and placed with adoptive parents, purportedly in their best interests. To date, this recognition has come mainly from the collective lived experience of birth mothers and adult adoptees being recognised and valued in public understanding of the past. But what do the archival sources from the time say, and how far do they support or contradict these lived experiences? This talk will answer this question in two ways. Firstly, by exploring what is on the record through surviving government archives, and secondly, by considering the widespread destruction of adoption case files, problems about identifying and accessing them, and how they are assembled, leaving valuable information off the case. Ultimately, the talk shows that there is a clear paper trail from individual coercive adoption practices to the heart of decision-making by the British welfare state. So if we've kind of got the short version of it. So Mike, if you would please fill in the details, take it away. Thank you.
Okay, thank you ever so much for the introduction, for the opportunity to come and speak and talk a little bit about what the archival side of the record says about historic adoption practices. So, before I go any further, can everyone see with the screen? Okay, so I mean, thank you. That's an excellent, comprehensive introduction about what I'm trying to do. And I'd say, although I'm answering those questions in two ways, it's very heavily in favour of the first, because the problem of destruction is inescapable, which means I have to sort of talk about it in broad terms, what it means that I can't say effectively. So I'll just begin with a bit about what I can and can't say through the records available, and why I'm talking in historical terms and about a particular moment in time. So on a broad basis, what you've got on this screen is the front cover of a government file from the Welsh Board of Health covering policies towards unmarried mothers and their children. And you can see from the dates, it's from 1939 to 1963. And I'm going to be sharing a lot of these files and their contents throughout the talk, just to give you a sense of what it's actually on them and what they contain. Just to have you a sense of what it looks like, the number is the code, effectively, where the file is kept. And then the fact that it says file closed means it's accepting no more papers inside it. So they start a new file. Then all the names and the dates on the front are the civil servants who've taken the file out and done something to it. So they might have put some papers in, taken some papers out, or had a read and made some amending accordingly. And then the closed until date is when that file was closed to anybody who wasn't in the Welsh Board of Health, was no longer in existence by then, but in the successing Welsh office. So at that point, 1994, that file was open to all to see from a period. So archival files, what are they? They're the records of the activities of government in this case, but also religious organisations involved in adoption. And there are different categories of these records and files. And these are at central government, like this one here, the Welsh Board of Health, and local government, so local authorities as well. Now, some categories of file, there are legal requirements to keep them, preserve them for forever, because they're deemed of historical value, whereas the vast majority of them are destroyed on a routine basis. This means that the surviving files, they're closed, usually for a period of either 30 or 20 years after the last file that was put in them. So the file on screen, you can see, was closed in 1963, 30 years later, and a little bit more, 94, it's open. Policy files, which concern or mention individuals by name, they're closed for a longer duration because of confidential issues, which means that they're closed for 75 years. But the principal source of information, social work case files, that is information about individuals, apart from those that they concern, and obviously there are problems about redaction and information not being shared and withheld, which we'll come on to later on, they're closed to anybody for 100 years because they're people more than likely still alive in that period of time. Now, academic researchers can, and I have, and I'll talk a bit about that, sometimes access these types of closed records with privileged permission, but the permission to look at them within the period of time when they should be closed to everybody has to come from the organisation concerned. So it means that the process of allowing who or who isn't allowed to see these records before they should become made public is entirely down to the organisations whose records they are. So there's a real conflict of interest almost in any kind of transparency about making them accessible for legitimate historical research purposes versus the contents of those files and the fact that they might be problematic for those organizations in terms of their reputation. So this means ultimately I am talking about historical, even though I would say a lot of the issues still run into the present and there are an awful lot of continuities, that the types of files and materials and sources that I'm using means that I'm very much talking about the historical moment in time, which is roughly from about 1940 until about 1980, when the paper trail starts to thin out and I can't get access to more recent information. So that's why I'm talking about this historical moment in time. Why do archives matter? I mean, it's a broad question, because what are they going to shed light on we haven't already seen before? So the way that I've got these two things next to each other is that Peter Hennessy is an academic of modern Britain, and he wrote a book called The Hidden Wiring, where he talks about the behind the scenes work, as it were, within government, within the establishment, within the leading members of society, about how decisions and policy and actions actually happen rather than how they say they happen. And so this is why I've got here a copy of what's, a piece of legislation, statutory instrument, which sets out how adoption agencies should be run, regulated, maintained, and all of their paperwork and everything else. And there's a gap and there's a discrepancy between what they say should happen, which is this statutory instrument here, and what actually happens. And you only really get a sense of that when you go through the archives, because it's just page after page after page of discussion about what is happening, and it shows a lot more of the behind the scenes, a lot of the thinking that's going on, rather than just what they say is happening. And so it allows you a slightly different picture of the past. So I'll begin just by sort of reiterating what Lindsay said effectively, that the reason that I'm sort of here today is because of the Joint Committee on Human Rights Inquiry into historic forced adoption in England and Wales, so not Scotland, between 1949 and 1976. And those are the years of the Adoption Acts, which kind of bracket the period. And the key thing that the inquiry did in trying to look again at the past was not go through documents and archives, the kind of stuff that I did. I was one of the expert witnesses on the first session, along with Dr. Jacinda Sandhu and Dr. Gordon Harold from Cambridge University, where we were just sort of trying to provide a bit of background, because the main purpose of the inquiry was to hear from people affected by practices, both birth mothers and adoptees particularly. And so along with the oral testimony session, which I've got a copy of here on the screen, there were more than 100 written testimonies as well, which fed into the inquiry and were included or often verbatim used in the final report. And so that's the key thing here, is the inquiry, the way of looking again at the past. It was driven by personal experiences and obviously a lot of campaigning behind the scenes in trying to get this in motion. So that's the context for this. So as many of you will know, the inquiry reported in 2022 saying that the government, the UK government, should apologise for what took place, and the number of recommendations should then happen as a result of this, recognising historical injustice and putting some measures in place around redress, and then also changes in access to information and things like that. Problematically, the UK government read the report. They took a long time to reply, longer than they should have done, and they effectively said, and so I got the highlighted bits on screen, so I want to sort of talk through the implications of these, that they shouldn't do anything, that we're sorry that this happened to the people affected and concerned, but ultimately there isn't a need to act. And because they said that the state, crucially, in the sort of the first bit of the quote, state did not actively support these practices, that adoption practices during the time, in that sort of 25-year period, 30-year period of so-called classic adoption, when the welfare state didn't really change very much, they were carried out locally when, and this is the quote they use, when the state's protections were more limited and guidance and procedures localized. And it also goes on to say adoption practices during this period were largely the responsibility of local authorities, although the direct involvement varied. So what this is saying is, during that period of time, despite all these lived experiences coming in saying about the long-term impacts they are having, that was beyond the government's control. It was other organizations, local authorities, religious, voluntary, other bodies responsible, not the state. We shouldn't apologize. That's the end of the matter. So there is an issue when you're relying on the lived experiences of people without any kind of additional information in trying to put this across. And this comes through in the work of philosopher Iris Marion Young, who sadly died quite a number of years ago. And she talks about this in a way that historical injustice So if it's individual perpetrator, there's a much clearer way of linking what they did to the outcomes that then came from it, whether that's through court, whether that's through a process, whether that's through a documentary, paper trail, whatever else. But when you're looking at things that are more than one individual, there are lots of different figures involved in a very complex assemblage, and you have to then piece it together, and it becomes very, very hard to kind of trace clear accountability. The government's kind of relying on this in a way. And she said at the time, in Springman, she's talking a lot about historical Nazi war crimes and the extent that individuals responsible versus the state. She said that these structures produced and reproduced by large numbers of people acting according to accepted rules and practices, that it was society, not us, go. And it is in the nature of such structural processes, so bigger than individuals, the kind of the following orders process and who's making the decisions when it's very, very unclear, that the potentially harmful effects cannot be traced directly to any particular contributors to the process. So it becomes more and more diffuse and fragmented the further you look. And even though there were clear commonalities in terms of the stories of people's very difficult and traumatic experiences of adoption, both in terms of birth mothers, young, vulnerable women, and also their children and the lives they had afterwards, the government was saying, link that to their decision-making processes. So what I'm going to do is just talk very briefly about how people have talked about the state and what the state is, because it doesn't get any clearer. So there are two quite influential theorists who talked about this in recent times. So Michael Mayer, based at University of Liverpool, he wrote a book called The Problem of the State, where he effectively unpicks the different philosophical ideas about who thinks the state is what, how we can draw a line around it. And that's really, really difficult, because when you think about the state, you might think the nation state. So this idea of different countries, sovereign countries doing things, international relations, diplomacy, all that kind of stuff. And yet at the same time, the state is responsible for emptying the bins every week, or other kinds of things at a much more smaller level. And trying to have a definition which encompasses both of those at the same time is really, really difficult. And so the same thing happened with Bob Jessup, who's been writing about the state for 30 plus years. And so the reason I've got these quotes on screen is just to give you a sense that they have these very long, complex, long-winded definitions about what they mean. But ultimately, and that's the bit that I've highlighted in both of them, is that they're bureaucratic structures, they're government plus entities, effectively, that kind of filter out. They're institutions, and they're not on their own. They connect together. They relate to one another. They are high in central government, the Houses of Parliament, Westminster, in Whitehall, where civil servants operate, but also in county and town halls and social workers walking out on the street. That it's all of those at the same time when you're trying to understand the state. It's a complex assemblage. It's a piecing together. It's like a jigsaw almost. So if you take that and you then piece it together with what people were writing about it at the time, have written about it sort of subsequently. So one of the ones that I'm drawing on here is J.A.G. Griffith. So he was a scholar of legal profession. So he wrote very influential books like later on called The Politics of the Judiciary. But he also wrote a book about trying to understand the relationship between central government and local authorities in the 1960s, when they're kind of really doing most of the day-to-day work about the welfare state and what it was and what it did. And he said, with that, he's got his tongue in cheek, but the working relationship between central government departments, so maybe the Home Office, the Ministry of Health, Department for Work and Pensions, those kinds of central government departments that still exist in different name forms today, and local authorities. Now, that could be local government, but that could also be local health authorities that are providing things within the NHS. In England and Wales can be regarded in terms which are formal and informal, statutory and non-statutory, legal, extra-legal, financial, official, personal, political, functional, tragical, comical, historical, pastoral. So government is doing all of these things. They're contradictory, and they occur often at the same time or at different moments in time as well. And trying to tease out what is happening and where is really, really difficult. You've sort of got to look at what is happening, and that's what he does in his book, effectively. He then examines how these things happen. And so the next quote I've got, although it says it's from 2015, is actually from much earlier. It's a series of essays. It's from Roy Parker, and he was a very influential professor at the University of Bristol, right in the 1960s, 70s, right the way through until the more recent years, until he died. And he's very much involved in a lot of the decision-making around policies towards children and families during the 1960s, right the way through. And he says that law and policy are sometimes confused when you're trying to understand these different roles. Legislation may certainly embody identifiable policies, but it may deal with little more than procedural matters that hardly amount to policy and very little in reality, as the case of the statute instrument on adoption regulations I showed you a moment ago. On the other hand, policies may be developed independently of legislative requirements, either explicitly or by default. So not every big decision that takes place about what should happen or shouldn't happen crosses the minister's desk almost. It can pass through very junior civil servants and still have very significant ramifications and consequences for people's lives, effectively, about how things are taking place. So when you're talking about the state, there are different levels, and higher and lower, and how far different things kind of go up the system. It depends, again, on how far they're sort of filtered, and also down, that ultimately bureaucrats and different officials are also blocking these kinds of processes. And it's very, very complicated because there's no single way of understanding it. It depends on what is happening and when. So these kinds of paper documents that you can say the government are doing X aren't always true, because behind the scenes they're doing different things, or a more complex variety of things that belie this kind of really complex structure behind the state. And so the quote I've got at the bottom is by a very famous historian of the welfare state, Jose Harris, who very sadly, again, died quite recently. And she wrote about the state, and she was really interested in intellectual history, and how people understood what it was and how it operated. And so she was interested in the state as this kind of military enterprise, and how from being the state in the Victorian period, going off and conquering the world and colonialism, all the other kind of things, how it then got involved in welfare and these very domestic issues. And so she's writing about this kind of period of transition. She says that the sheer size and scope of the new social services meant that welfare, because it's a very broad and ambiguously defined term even then, let alone now, increasingly rivaled traditional spheres of what the state did in terms of defence, property, and public order, as fundamental rationale and purposes of the state's existence, what it's there to do, and why it's there to do it. Yet, and you can see this, as I'll come on to in a second, about the actions of how officials worked, is that any serious attempt to explore and defend the legitimacy and implications of the role of what the state was doing and why was conspicuous by its absence. It just carried on doing because it always done. And it just carries on reproducing these processes without any serious interrogation about, should we be doing it? Is this problematic? Is this harmful? And so that's why I kind of want to summarize in the last bit of that process there. So what I've got here now is why I ended up contributing evidence to the Joint Committee on Human Rights inquiry. So my background wasn't in understanding adoption practices. My background was understanding the complex workings of the welfare state. I was interested in so-called problem families. That is, families that present disproportionate problems to the state, to the welfare services, because they consume a lot of resources and money, different government departments, different agencies, and a lot of time by social workers. And so naively, because it was incredibly thorny and complex, and I was going through these case files that I was allowed privileged access to, and no two were the same, even though there were a lot of commonalities, and trying to understand how these different officials were making decisions on families, I had to understand the whole kind of professional spectrum. So that inner ring around the case file is a series of professionals who were involved in policies towards children and families at that time. So on the left-hand side of the screen in the blue, you've got WO, welfare officer, FCW, family caseworker, CCO, childcare officer, all these kinds of professionals, but they weren't acting in a vacuum. They weren't just doing things because they wanted to or they could. They were doing a job. Social work was work. They were being paid to do something, and they were being paid by the Children's Committee. Now, that was a committee of the local authority, and how they actively recruited staff, went out and decided what was happening, what wasn't happening, funded homes or different kinds of activity. That wasn't entirely down to them. They were taking instructions from the Home Office, the central government department responsible for overseeing children's welfare at that time. And so what I was doing during the course of my PhD was tracing every single one of these connections, these processes of authority, because it also applied to voluntary organizations. Because lo and behold, when I was going through the files that I was doing, there were 2,000 of them in the end. Forced adoption turned up a lot. Unmarried mothers living in poverty, having their children removed from them because they were unmarried, turned up a lot. And in tracing how those decisions were being made, by who and why, it then led me to this. I mean, I've simplified the kind of final version, but I'm trying to fit everything on the screen. But just to show you the different range of individuals involved, the different government organizations, but also the different voluntary religious organizations involved, that process of tracing accountability and responsibility, who was doing what and why, was the entire purpose of my PhD. And during the course of that, that's when I came across adoption as an issue where I could show this clear line of accountability between decisions being taken in their child's best interests and the mother's best interests by a social worker who was paid by voluntary organisation funded by the state, once that in a second, And ultimately, the decision about that was being taken as far away in the Church of England Board of Social Responsibility. And that's what I was doing effectively. So it's understanding those complexities that's the source of my kind of interest here. So that's kind of the preamble almost, because what I want to do is show you some stuff effectively to kind of give you a sense of what's going on. Because ultimately, the Joint Committee on Human Rights was about England and Wales. It wasn't about Scotland. It wasn't about Northern Ireland. And what you have after the JCHR report is then returned by the government. And they say, we're sorry, we can't apologize. Well, they don't say we're sorry. They say we're sorry 15 times, but they never actually mean it. They refuse to apologize. Then Nicola Sturgeon, one of her last acts, comes out and she does make a formal apology on behalf of the Scottish government. And she says, as part of this, obviously very cutting political remark to Westminster, she says, now there's a line of argument which says that because the government at the time did not support these practices, come back to that in a second, there's nothing to apologise for. And that anyway, these events took place long ago, before this Parliament reconvened and anyone in this chamber held public office. But she goes on, these are not reasons to stay silent, because ultimately it is the state that is morally responsible for setting standards and protecting people. And so she's having a dig, but she's also making a very strong point about why some action is needed, why some action should be taken. So Scotland is different, and there are very material, real reasons to understand those differences. So I was also alive to this as well. So several years ago, I was commissioned to do a piece of research for the Scottish Child Abuse Inquiry in relation to the Fairbridge Child Migration Society, which existed from 1913 until 1982. And it was, as many of you know, sending children to farm schools in Canada, Rhodesia as it was then, and Australia. And part of my responsibility was to understand policies and practice, because understanding kind of complex governance was what I do. And in particular, in terms of this, it was about identifying children who were from Scotland who were going, and the responsibilities of the Scottish government to have over these children to ensure their welfare is maintained. So even though my PhD is on England, even though I'm talking about England and Wales, and I'm kind of showing you a bit of that, I'm conscious of the different Scottish dimension in a number of legal, policy, and professional ways, and why, although there's some similarities, it's also important to be mindful of differences about what makes Scotland different, and those that aren't part of the subject of the Joint Committee on Human Rights report. So what I've got here is what other academics have said about that nature of that relationship, the welfare state between Scotland and the rest of the United Kingdom. And so you've got a couple of important kind of historical quotes about this classic period in sort of the 1940s through to the 1970s, where they talk about the powers that the Scottish government, the Scottish office, I should say, had at the time, because formal devolution didn't happen until 1999. So the term administrative devolution, where the Scottish office and its different departments had greater autonomy for its different social policies and welfare practices, that notion was invented by a civil servant proposing reforms aimed as a response to agitation for Scottish Home Rule in the early 1930s. The term deliberately conveyed the idea that the Scottish office represented a form of self-government. It goes on to say that it's not an example of devolution, which would involve capacity to make authoritative decisions and responsibility independently of Westminster, nor was it merely just different, like English subordinate departments, basically. That Scotland was an example of territorial division of administrative responsibilities existing alongside functional ones. So that, again, in terms of that complexity, there's a blurring. But they go on to say that the unity of cabinet government, the principle of how policy is undertaken in England, Wales, and the United Kingdom, to the unitary parliament, because MPs are still representing their constituencies in Westminster, are in no way affected by this. But they go on to say that obviously there is a distinct pattern of what Scotland's doing. So what this is saying, importantly, kind of reading across the kind of traditional academic way of obfuscating everything, is that Nicola Sturgeon is apologising for something for which at that time the UK government was formally responsible for. They're not the only people to say this, because another influential book here by Lindsay Patterson talking about kind of this welfare route to Scottish autonomy, then kind of culminated in devolution in 1999, is that the UK welfare state, and that's the same one that Josie Harris is talking about in that quote I used earlier, took a distinctive form in Scotland, and that was also the previous author agreed on that, to such an extent that Scotland can be described as having had a welfare state of its own. But to understand the extent and limits of that, the key point, the politics that mattered weren't those of Parliament, they were of the bureaucracy. So again, understanding how there are similarities and differences in Scotland between England and Wales and what this means in terms of outcomes in the history, you can't look at these formal, big, high political structures because they won't give you the answers that you're looking for. Because the state It's a bureaucracy. It's a series of different institutional, organizational relations. You've got to look within the state for that answer. And so again, some people have written about this, and these are names, if for those interested in particularly the Scottish dynamic to this, people who've written quite authoritatively on both adoption and its similarities and differences in Scotland during that kind of classic period, and what that means in terms of trying to unpack the kinds of records that you're using. So Lynn Abrams, again, she's been an expert witness to the Scottish Child Abuse Inquiry. She kind of affirms this earlier point that there's a distinctive Scottish dynamic to what is happening that you can't overlook. And this is echoed in the work of Janet Greenlees, who's an excellent academic at Glasgow Caledonian University, who's written on this again over a number of years, and has again supported expert advice to the Scottish Government about this, where she says that there are different social attitudes as well as policy attitudes. But she goes on to say sort of later on that you can't say that there is one difference, and there is a Scottish version and an English version, because there are similarities, differences, and they change over time as well. So that these social attitudes, these cultural attitudes, aren't just innately national or anything else, that they're related to how policy and practice are implemented and developed. And crucially, in thinking about those similarities and differences in that period between 1910 and 1950, mentioned in the previous quote, that this post-war welfare state, the one after 1945 that ran through roughly until the 1970s, when it kind of unraveled for financial and political reasons, that has a similar dynamic in Scotland as well, because Lynn Abrams goes on to say that even in Scotland, where there had been this distinct difference almost, and a conscious way of trying to have administrative devolution, doing things differently, a distinctive Scottish way, often trying to be more, as it is now, in theory, more progressive than Westminster. And that attitude was very much embedded at that time as well. But she was saying that even in 1945, in terms of adoption particularly, times were changing, because the kind of the fostering, boarding out model that Scotland very much relied on, that was starting to unravel, because the number of people available to do that was declining, which then meant, in terms of the temporary nature of fostering versus the permanency of adoption that underpinned that, adoption also became the normalised model in Scotland at the same time as England as well. So when you're talking about this Scottish progressiveness, this Scottish difference, you have to bear in mind that there are an awful lot of similarities as well, and you can't overlook this kind of difference. So when you're talking about kind of the policy understanding, it's not Scottish exceptionalism, it's part of a wider English, English based, but UK model. So, having said all that, there are a lot of records held in the national records of Scotland relating to historic adoption practices that are open to the public and mirror what I'm about to talk through, the English version. So I've not had permission or the opportunity to go through the Scottish files in the same way that I have with the English ones. This kind of slide is to say they are there. They have very similar names to their English counterparts, and I can trace some of their relationships. I'll show you some of those in a second, because there are English files that talk about these files and about trying to make sure what Scotland's doing, and there's a constant conversation. So it's not as if they're independent. There's a constant discussion about, can we let Scotland do this? Can we not let Scotland do that? And the Scottish civil servants trying to push in a certain direction or not at different moments in time, because this crops up in the English files as well. So this is just to say, shamefully, given what I've said about being sensitive to particular circumstances in Scotland, I'm going to use exclusively English files to talk about what I'm about to do. But that's because I've not seen the Scottish ones, but they are there and they do warrant investigation, because without looking at them, you can't possibly know, but I would have a very strong sense from what I've seen to date, what the kinds of things inside them would contain and the kind of problems about accessing those as well. So this is just an example of one of those files. So this is a file held by the English Home Office. It was then deposited. It's now open, where it's talking about discussing changes that Scotland's pursuing in relation to their own adoption policies, because in Scotland, it wasn't run by the Home Office, it was run by the Education Department. They ran children's services or oversaw them at the very least. So this is to say that there's even just a file on its own talking about that kind of alignment between England and Scotland. And it's those kinds of files that I'm talking about and using to try and understand these similarities and relationships. So, bit of archives. Couldn't not have any kind of presentation without showing this. So this was my kind of proverbial way of showing the UK government that their line, that the state was not actively involved and they didn't know that forced adoption was forced, can't really be sustained. So what I've got here, I'll work my way across the screen from left to right. This is a English Ministry of Health file. It concerns Section 22 of the National Health Service Act. That is, it cares for mothers and babies. And that was instituted as part of the 1946 NHS Act. And you can see from the bit below that I've highlighted red, that it relates mainly to Church of England, Moral Welfare Council, and the National Council for Unmarried Mothers and her Children. And by and large, that's what the exchanges in this policy file concern. And you can see from the cover, it's been taken out a lot in terms of the information that's been added to it. Cut to the middle. This is a motion from the Standing Conference of Societies Registered for Adoption in 1951. So the Standing Conference is the umbrella body. There was a Scottish equivalent which started slightly later, and they had constant exchanges with the English version, well, the English and Welsh version. So they're at their very first conference. So the 49 Act only comes into force in 1950. And this is the first time when all of the social workers, bearing in mind that representatives from the Ministry and the Home Office are attending this conference event, the first time they have to get together and talk about what is happening. These are the organizations registered for adoption. They're very pro-adoption. They think it's the right thing for mother and child. They're invested in the norms of that time. So the closed adoption ideal, the blank slate, the idea that the child aged between 10 days and 6 weeks is impressionable enough that they won't be impacted with all the negative neurotic associations that their mother may have had. And by giving them to a better, newer adoptive family, we can solve the problems and save money for the state in terms of childcare, residential childcare costs down the line. That they're invested in this ideal and they're pushing for it. But even they, in 1951, right at the very start, say mothers of children are driven to adoption. The idea that there's a free choice, conscious relinquishment, that there's a real decision where people are informed of all the circumstances around them is simply not happening right from the get-go. And the bottom part, quite strong language, even by the standards of the day, where they say that she is forced apart from the baby, whether she wishes it or not. So the government, the UK government, have been told in no uncertain terms, choice is an illusion. You haven't really got a say involved in this process. What do they do? So if you then look at the final handwritten part, in very officialese, Oxbridge legal kind of terminology, the civil servants pass this document to each other. What should we do? Who's responsible? Who should we talk about it with? But ultimately, they say that the questions raised are far larger than the legislation that they're talking about. But because they talked about that, we're going to reply and speak to it. And the below bit discussion then carries on over the page, effectively says, we're going to do nothing. So they note that this has been received and they reply to the Standing Conference saying, thank you very much. They outline the number of powers that are available, but ultimately they recognize the language of force of no choice, whether she wishes it or not. They know about that. They've been told in no uncertain terms by pro-adoption societies, no less. And yet they choose to do nothing. It's a conscious choice. So in a way, it's easy to see this kind of continuity of the classic welfare state period as it was just unchanged. It carried on. But what is happening behind the scenes is the adoption societies themselves are concerned about what's happening. And they're informing the government, and the government is quite happy with what's going on and chooses to do nothing. And that's an important distinction to make. So the thing that I want to talk about, because it's a good example of seeing across the different nations, is where the money comes from. So I'll talk about it slightly later on, but the main reason I'm talking about money in very tedious ways is because often records are closed. For a whole variety of reasons, because the reason I kind of laid out at the beginning. But the records that are usually open are financial ones, which means that it's a lot easier then to trace the kinds of relationships I have through money, follow the money train effectively, rather than individuals in quite the same way that I would like to do so. To kind of show this more comprehensive bit. So what you have here, before the 1949 Adoption Act, is a circular. So that's an instruction from the Ministry of Health to welfare and local authorities during the war. So this is when adoption was changing. So before the Second World War, primarily, adoption was quite small in number. And the purpose of mother and baby homes was to enable the mother and child to stay together. Now, that wasn't out of some kind of ideological drive that was in their best interest. That was a way of saying that mothers should carry their shame, their stigma with them throughout their lives. And the purpose of mother and baby homes was to train mothers to be domestic servants effectively, because if they become domestic servants, it also solved the problem of accommodation, because often unmarried mothers really struggled during the interwar period to get housing, because they were viewed as an undeserving group by local authorities who refused to consider them, and often private accommodation was very expensive. Bearing in mind that mothers in these circumstances are both the caregiver and worker, so either they're going to have to put their children into a nursery, and a lot of them didn't accept that, or more often into residential care, which then really disrupted the relationship between mother and child. And so the idea here was to provide training, domestic service, because it's also solving a domestic labour problem within service, because it's a very hard, unpopular job. So obviously the Welsh do think that's a great idea as well. So this is when it transforms, because the numbers of prospective adoptions increase during the war, because often people who may be in a relationship may have otherwise got married, that's interrupted because of the war. They might go off, they might die, there's all sorts of reasons. And it's also, from the point of view of ministry, about maximizing labour participation in the marketplace. You know, the war effort, effectively, we need to mobilise everyone, unmarried mothers and all. And this is how they go about doing that, by doing something. So the key bit I want to look as part of this instruction that is being sent out is that they should take responsibility for unmarried mothers and their children. And the way to do that isn't by having some transformative new service. It's not by changing the dynamics that's already there. It's about allowing the voluntary organisations who are already running mother and baby homes to continue to do so, because they're quite happy with that. They like what they're doing. But what we need to do is provide money for them, because at this point, they're very financially precarious. They're reliant on donations a lot of the time, the great good and philanthropy. And it's not the most popular cause in relation to others. And so they're constantly struggling for money. And then what happens here is the Ministry of Health say, okay, we will subsidise local authorities to pay the mothers to go to homes, and also pay to subsidise the homes in the first place. And this completely transforms mother and baby homes from being quite a cottage industry, relatively speaking, into an industry. And that becomes the adoption industry. And you get a sense of this from this other note that I've got here, which is a response to the circular shortly after it was issued, when they're trying to, the Church of England here, publicise this circular amongst their members, amongst moral welfare workers, because the number of moral welfare workers just explodes as well. And when they say, I seem to be always bothering you about this circular, bearing in mind it's just over 6 weeks since it was first issued, but that only shows how important we all feel it to be. And it does, it completely transforms things, because it provides financial certainty of the relationship between the state and the voluntary organisations providing this essential service that they want. So what you have here, in a way, you're trying to say the hidden wiring of government, effectively, because there's a way, like you could do with the Inquirer, you could look at things starting with the 1949 Act, ending in 1976, and viewing that as kind of a closed, book-ended period. But already I'm saying it's happening in 1943 because the government's starting to subsidise it. So what you have here on the left, within the file, same file that the standing conference paperwork turns up in, is that they're responding to a letter that's come from an MP that's come and that's talking about what actually is the official ministry position in relation to mother and baby homes at this moment in time, and what are they doing. And so they're trying to clarify just the Ministry of Health here, not the other government departments involved responsibility. So the first one is saying regional boards make no separate provision. So they're not kind of doing things separately, because mother and baby homes are provided by local health authorities. That is local authorities and their kind of health services. But they make no provision for the confinement which the mother is transferred to hospital. Question of costing, because they're on about money. That's the paper trail that I'm following. Who is financially responsible for paying for this service, effectively, because local health authorities were financially different from regional hospital authorities. And so it comes to this bottom point here. Now, this is a ministry internal circular, an internal memorandum, sorry, 1952, where they're trying to kind of iron out what it is they're doing. So point 3 leaves you with very little room for uncertainty, that the great majority of mother and baby homes are provided by voluntary organisations and the various religious bodies. And that is true right throughout the period, that they are the majority. Some are run by local authorities, but not very many. These homes are almost without exception subsidised by local health authorities under Section 22 of the NHS Act. Now, don't let that trick you into believing that the central government, therefore, is out of responsibility, because it's the central government who are paying for these Section 22. And the financial formula varies by local authority and how much money they have and how rich or poor they are. It's more equitable at this time than it is now. But effectively, local authorities are paying for voluntary organisations, and central government is paying this service to local authorities. There are only a few which have been established by the LHAs, that's local health authorities, so those run by local authorities themselves. And so the writer, the MP, Ms. Coney, is clearly unaware of the provisions for the unmarried mother and her child, and might refer to Circular 2866, one I showed you just a moment ago, of which a copy is attached. It's all over the place. Although the circular was issued in 1943, the information is still relevant and represents our present policy. So even though the 49 Act's been in place and changed how adoption is taking place, in terms of the formal law, you know, what the government is saying, and that's the bookending of the JCHR inquiry, what started in 43 is happening in 52 and just expanding. So this kind of really small, really tedious financial document that's only about 7 paragraphs long dictates the terms of adoption finance and policy throughout, and that's the case in 52. There's a similar document in 1968 that says very much the same thing, but that's still the basis for it. So in terms of who's responsible and where, the other page, This is a separate, so it's not connected to the first document directly. It's a few years later, and it's a message from Ministry of Health to the town clerk, that's kind of like the chief executive of Halifax local authority, because they're asking effectively about who is financially responsible for mothers. Is it the authority where they had the problem in the first place, or is it the authority where the mother and baby home is? So the background to this is local authorities that had a lot of mother and baby homes in them, including Blackpool, were really hacked off because they ended up paying for it in the interim. And also it meant their annual reports to the ministry on the numbers of illegitimate children meant that their stats looked bad compared to everybody else's, and they were really annoying. So where is the financial, where is the organisation responsibility? And what this document shows, because it's just a wording, it says that I'm directed to reply and to say that while the minister has no authority to interpret the Act, that is the 1946 NHS Act in relation to Section 22, mothers and babies, he takes the view that the local health authority in whose area an unmarried mother is residing when the need for care, what a lovely euphemism, under Section 22 arises, would be responsible for the provision of any service required. So this document shows two things. It shows you just how much the central government knows about what's going on, how much they're controlling it. And also, two, the idea that there is some kind of formal written down legal responsibility over this that you can trace. It's not entirely the case, because they say we have no legal authority to interpret the Act in this way, but we're going to do it anyway. So the reason I'm showing you this is because there is a different inflection almost between the different, well, now devolved nations, but at the time they were the Scottish Office and the Welsh Office, which starts in 1964. So this is the same circular issued on the same day, but it's the Welsh version. And it's written slightly differently, got slightly different wording around, because they like to do things in their own flavour, but effectively the same relationship between paying for mother and babies homes and adoption is embedded in exactly the same document. But in the discussion about how they're going to enforce who's going to look after making sure the quality of care being provided is adequate, there's a minute slightly further on, just after this, a couple of years later, where one civil servant is saying, we're trying to make it clear effectively, because there's a lot of ambiguity, that where local health authorities subsidise, and again, using that word subsidise, such homes, the responsibility for routine visits, so making sure that the quality of care that is being provided is acceptable in their point of view, should lie with local health authorities concerned, and our officers should in the ordinary only visit some special reason. What could those special reasons be? So what I've got here is an open file. This concerns the an unmarried mother shelter in Swansea in 1963. And what you have here is an example of what the Welsh Board of Health, and they're very similar files than the English ones, but I'm showing you this one just because it's the home that a few years later Anne Keane, who was in the earlier slide, she's the Labour MP who was birth mother herself and had a child taken off her. This is where she would have that experience a few years later. So this is in 1963. And I'll just read it out because it's pretty frank, to be honest. So that the warden at the time, Miss Robinson, interviewed by the officials who were going to check on the home. And she gave us the impression that she was a very hard-hearted person, just the person you want looking after vulnerable young women, and stated proudly that she had years of shelter experience. So shelter are smaller kind of mother and baby homes, effectively. They're very, very tiny, and usually in a few beds. And in many of the toughest parts of England, her manner and attitude bore this out, and although underlying it, she could be kind. So read between the lines.
Michael frozen.
Yes, I thought it was me, but no, you're
No, I thought it was me as well. He might come back. Wait, and I'll see. If you just give us 5 minutes, guys, we'll see if Michael's lost his internet connection.
Right at the good point too, right at the where it's all unfolding.
I was literally like
hanging on this next word. Yeah. Oh, well.
Right, let me go. I'll be back in a minute. I'll go see if his link's working.
Apologies, not quite sure what happened
What's
there.
the way to say, if he comes back, he knows how to get in. Don't know how to let you in.
Sorry about that. Right, let me try and pick up
Right.
my full flow. So, back to the document. Where was I? Well, I'm reading through it probably yourself at the same time. But effectively, so wait. This Robinson's reaction was to ring Mount Pleasant from midwife, very much she's not midwife. Some time elapsed before mother and baby were transferred to hospital while Miss Robinson was arguing with the night sister, who insisted that she could not spare a midwife at that time because they were very busy. An ambulance arrived later, and mother and baby were taken to hospital. The warden was more concerned about the cleaning up than her own inefficiency in transferring the mother to hospital when she first complained of her pain. Pause. Another confidential incident has also been quoted, where a 15-year-old was left to deliver herself. Warden failed to accept the fact that labour was imminent. So these kind of routine reports on what is happening in mother and baby homes coming from different inspecting authorities say similar kinds of things. They're very damning indictments of what is taking place. Now, this is probably on the worst end of the spectrum, because shortly after this, the ministry insists that they close it down. There's local reorganisation within the kind of religious bodies involved, and they open it about 6 months later on. Because, again, thinking about the official language that's used, they say here quite bluntly that ideally, the provision of a separate home for unmarried mothers with an ex-midwife in charge is desirable, and that's ultimately what they get. Bear in mind that those similar dynamics about the kind of harsh attitude still remain in place. So here's the Scottish example, is the bit. So this is the same circular, talking about the same financial relationship, endorsing the same relationship between local authorities and voluntary and religious organisations, funded in the same way by the Scottish office. But again, just like the Welsh one, it's slightly different to the English one in its wording and how it's articulated and how it's put across. That the ultimate principles in place are effectively the same. And so that the reason that this is here is because it's part of a series of exchanges from the name of the file between the ministry and the Scottish Department of Health, effectively making sure that they were aligned, that there were enough similarities, that there was no fundamental difference, but ultimately it was still maintaining that separate Scottish route that was kind of desirable and that talked about from those quotes earlier on. So in terms of that financial relationship where the state says, this is a practice that we want, we are going to financially subsidise it and support it so that it increases, and that's when it goes from being a cottage industry into an industrial one of the post-war period. Same thing is happening in Scotland. And again, this is just the reverse of that same document, where effectively they're saying that the Secretary of State would take effective steps to ensure that close and mutually sympathetic, I mean, they love these kinds of long-winded ways of putting it, cooperation between local authorities and officers and the voluntary organisations. That is that preferably, rather than do things new, afresh, costly, expensive, these existing organisations in place are what we want. We can just repurpose them for our new functions. And we'll do that by subsidising and paying for what they do. So the reason I've got this up is to try and show that I've not looked through the Scottish documents in the same way that I have for England and Wales. So I don't have this kind of same intimate story to show you about those kinds of experiences. But what I want you to do is to try and think and read between the lines. If you think about the example of the shelter in Swansea, where you routinely got the warden untrained, pretty much unqualified, not knowing, she's been there for years in different ones, toughest parts of England all over. And yet she's no idea when people are about to go into labour, despite the fact she's been doing it for a number of years, and the consequences this then has. So they were still able to have a healthy baby that was then transferred to more appropriate adoptive parents. So the story goes. But in other cases, that isn't the case, and the more tragic outcomes for that exact same experience. What this shows is an official report, so it's very public-facing, it's very formalised, is that the same potential series of ingredients are at play. So they're talking about one run by the Scottish Church of Scotland, where they say that the mother and baby in Glasgow is admitting this number of girls and this number of babies. Throughout the year, the home was experiencing great difficulties because of lack of staff. And much of the time, Mrs. Harvey, the matron, was the only midwife available, so she was trained. In the latter part of the year, she herself was taken ill, and a special tribute should be paid to the part-time staff who carried on magnificently in her absence, and to the hospitals who undertook the confinement, which normally took place in the house. Now, at first glance, you'd read that and think, fantastic. They're doing all they can to care for the mothers and babies concerned in the appropriate way, the standards of the day. But put that in context of what you've seen about Wales, where they're saying that this is beginning to become unacceptable. And again, that's more on the extreme spectrum, but those kinds of experiences, no stories, are not uncommon. But this hints effectively that those same kinds of problems are in evidence in the Scottish example, and only by looking through the Scottish material and archives can you really validate that. But it's just about thinking about those similarities, those points of continuities between them. So coming on to the last bit, because it's all about it's lifelong. And part of the reason that I've been talking in so much about birth mothers, about unmarried mothers, about mothers and baby home is because those are the records that survive, because that is what the organizations were involved in doing. They wanted a continual industrial throughput of babies to be passed from these undesirable, unmarried, neurologically, pathologically unstable mothers to more desirable families. And you get a hint of this. So this is one of the professional documents at the time by a child adoption. So that's the Journal of the Standing Conference. And so this is an article, several pages long, dedicated to what is happening in one Scottish society. And the bits that I've picked out for you is try and give you a sense of whose interests are being served here. So they talk about this and then it goes over the page. So it is relevant here to make the observation that the policy regarding the selection of adopters and the placement of babies varies amongst adoption societies and children's department. Each society or department has its own views about particular guiding rules, and these are followed rather than objective appraisal of each individual situation. Now, what that actually is trying to say is that it's down to the societies about who they deem as a better parent. So often those decisions are being made on financial basis, that they're more affluent class families who are able to provide materially for the child's upbringing and emotionally and stably. But it's also about faith because of the kind of sectarianism. So in England and Wales, that was very clearly between Catholic and Church of England. But in Scotland, where it's far more sectarian, the different church organisations involved, that you can see that ensuring that the child's purported faith from its mother was being adhered to was one of the overriding issues involved. And again, thinking about the process of who is selecting, who's making the choices here. So here we go. For example, a reported history of approved school in one of its biological parents can be viewed by some as making a child unadoptable. Now, that idea harks back to the kind of interwar period where eugenics was very popular, and the idea that adoption didn't take off because children were contaminated, so they said, by bad blood, by poor heredity, that you were taking a child and legally adopting them, and they could have all sorts of pathological difficulties. No, thank you. Whereas in the post-war period, John Bowlby's ideas of maternal deprivation, child development came far more into fashion. The idea that children were a blank slate and they could be impressioned upon, and the earlier you impression upon them, the better, was part of this. So this is about trying to take, in the 1960s, the middle of the 1960s, shift away from that idea without inquiry being made. If the child is the second or third illegitimate child, now a lot of local authorities end up arguing continually with voluntary organisations, because a lot of voluntary organisations, their purpose is the rehabilitation of the mother. If she's coming back a second or third time, in their eyes, she's irredeemable, and they refuse to accept her, even though local authorities are very willing to pay for her to go, and have these all sorts of disputes at a local level about this. Would be viewed by some as a bar to adoption, irrespective of the other circumstances of why the woman had become unmarried in the first subsequent instance. There are various ideas too associated with venereal disease. Several files on that. The idea that all unmarried mothers should be compulsorily screened because they could be promiscuous and therefore warrant intervention. There are various ideas too. A birthmark is frequently viewed as making a child quite unadoptable, and such children may be automatically transferred for permanent care in a children's home or a foster home. So what I'm trying to get you to think about in this is the power that lies with adoptive parents and the voluntary organisations rather than either birth mothers or the children effectively. That part of the reason why there are so few central files on this is because they put down regulations. It's down to them to interpret it, mainly on religion, about how they develop suitability, and that ultimately they're quite happy for this kind of template to come into view, that the adoptive children, effectively, once they are transferred legally, morally, ethically into their new adoptive families, for all intents and purposes, local authorities abnegate any kind of responsibility and oversight during this period of time, but in no means. And so part of the reason why I'm saying this is because that's why I've talked about those files, because there's a clear evidential bit, because they were interested in doing it, they're financing it, they're paying for it. But once the child has been paid to then go into this new, better adoptive family, after these initial cursory visits, that's it. So important points to mention here. The JCHR inquiry was instituted by a select committee. It's not a statutory public independent one like the independent child abuse or Scottish child abuse inquiries. It had no powers to sequester evidence or demand things be revealed to them, compel witnesses to attend, so there are precious few voices of social workers or religious authorities coming and talking about their involvement in the process, or commission research, and that's what commission research that I did in Scottish child abuse inquiry. There are I've shown you in a very cursory way hundreds of relevant case and policy files, both in NRS, the National Records of Scotland, and NRA, that should be TNA, the National Archives of England. But they remain closed, despite my attempts and the attempts of others to access them, despite the fact that there are provisions in law to allow these access for legitimate historical research purposes. Voluntary and religious organisations who are completely subsidised by public money during this time are under no obligation to make records accessible, despite the fact that it's public money that's paying for them, because they're the records of those voluntary organisations. And so when you're looking in those key bits about suitability for adoptive parents, those files do exist, but they're in voluntary organisations and I cannot get access to them. And that released files, when you finally do get access to them, and they are willing to open up sections of it, they have large amounts of redacted material, such as this that I'm showing on the screen, which is about one of the most notorious examples of children being exchanged for money, effectively, that the ministry knew about. And whilst there are discussion points of that in the document, vast swathes of it are just edited out and not inaccessible for even sort of legitimate research purposes. And so again, here, to give you a sense of the value that's placed on due process in ongoing checks on adoptive families. So this question was raised by an MP during the middle of the 1960s. The idea that there could be a problem, effectively, in this closed adoption ideal of once you pass a child to adoptive parents, that they may not be the best possible adoptive parents that the paperwork may suggest that they are, and saying that what is the legal basis for inspecting? Now, there is a legal basis for inspecting, but the ministry and the Home Office determined that it's down to local authorities to decide when and where it's appropriate, because if they mandate it, they demand it at a certain moment in time, they've got to enforce to make sure that's done. It's very time consuming, it's very costly, you don't want to get involved. So here, in terms of what I talked about at the beginning, about the government, about due process, about policy, about legislation, about all of these really deep, significant things that they're trying to say they had no responsibility over. This is the handwritten note that becomes official government policy on this by a civil servant, where it says that in the absence of evidence that children placed for adoption are undervisited, because that's what the MP is suggesting, there are grounds for leaving discretion to local authorities within the existing framework of from time to time. So the welfare of adoptive children within families is entirely at the notion of from time to time during this entire classic period, which gives local authorities, so the ministry is allowing local authorities carte blanche to not do it because it's too much hassle to do it. And they believe they shouldn't be intruding in the lives of these newly formed, perfect, idealized families, despite the fact that they themselves are aware of growing problems of those families themselves. So what does this mean beyond this in terms of looking deeper into this? So many of you will probably know far better and with more harrowing experience of it than I could ever possibly do, that adoption case files and records are considered the property and responsibility of the organisation rather than the people concerned. So even when you get access to your own file, about your own identity, your own story, that you have that same experience of large subjective redaction or therapeutic access, which means that you can't see or hear parts of your own life story. That many historic adoption agencies that existed at the time, they're very small, they're very fragmented, we're in very small institutions. They've closed, they've merged, they've changed their names, or they've folded entirely. And so the trace of these very small organizations is very, very hard to come by unless they've been taken over by some larger conglomerate who are more committed to at least providing an opportunity to access these files. Files for the cases, they're quite frequent, but with each point of contact producing documentary sources. What do I mean by this? So the idea that there is a single case file is a bit misleading, because the mother and baby home will probably have a file. The adoption society will probably have a separate file that has sources of information you may or may not know about. They're not necessarily collated into one, although in some cases later on that they are. You'll then also have local authorities who are regulating these adoption agencies will also have a file about this process. And again, they're not collated into one. Now, you may not know they're there, but the local authorities involved may also not know that they're there, or because they're part of their routine activities, they may destroy them entirely. So I've been in the fortunate position, because it's the easier way to do it, where effectively you just have organizations copying all of this and saying, when referring them, there's a full copy. And lo and behold, you've actually got a full copy on hand. And I should also say there's an ethical problem, because I can then do that, have access to that within historical provisions if the organizations allow me to do so. Whereas if you or other people, even though you're the subject of that file, trying to access it, you wouldn't have the same complete access to that file that I have. And that is a very large problem, because it's not my history, it's many of yours own personal history. There's a real iniquity in access there that I think is not being fully addressed. You've also got to bear in mind that case files don't tell the unredacted, complete version of the so-called truth. They're not objective. What are they being produced for? The audience of case files are other social workers, they're other agencies, like judges and magistrates and other figures. And the focus is primarily on the health and legality of the child, in this instance, as an exchange, as a source of value to adoptive parents over the condition of the health of the birth mother. You saw that very clearly in the example of the Swansea. And that even when you get access to them, even in a restricted or redacted form, that the story that's being told is a very myopic, a very narrow version of that story. It shouldn't be constituted as the truth in a way that I think is a real problem, especially with inquiries, to give additional weight to these kind of archival sources. So when you see them and you understand the kind of off-the-cuff phrases that are produced and just common across files, and yet that's trying to give a very intimate story of you and your life and your circumstances, you need to read them with extreme caution about whether they're revealing truth or not. Because, I mean, you've probably experienced this, many of you yourselves, that names are wrong, dates are wrong, birthdays are wrong, relationships are wrong. And it's only when you can kind of corroborate and build a larger picture that you can see the gaps and problems in them effectively. So my last point, and kind of try and join this together. So hopefully you got a sense of the strengths of archival research in trying to get behind the hidden wiring, the weaknesses and limits of them, what they can't show, but also what that says about the attitudes of government at the time and about the particular circumstances of Scotland. So back in 2018, Alison McGovern, as part of a motion of trying to get an inquiry instituted, and the very first thing that she said that should happen is that before this inquiry is in place, what the government could do is that they could check all official records and documentation for evidence to relate to this practice and publish it. Now, I'm one person, I'm on my own, it's not my full-time position. Even with, going through maybe 100, 150 files in England and Wales over a 40-year period, in the kind of way of problems about access, about redacting information, about the relationship between these files and what's happening locally, even a reasonably cursory examination shows the extent of central knowledge, how far the state was involved, and how ultimately the financial relationship underpins all of the other elements of that relationship. And that includes the Scottish difference, that even though there's this notional progressive different dimension, there are different eras of the Adoption Acts in place, but the same purpose, the same relationship, the same purpose that adoption was serving. In essence, it's a kind of a child welfare measure, that in the best interest of the child, in the best interest of mother, this new life should be instituted. That was exactly the same place. And ultimately, she kind of says at the bottom that, lastly and most crucially, the government can say sorry and apologise on behalf of the nation. I know that's been a campaigning issue for many people, but simply by doing so, the Prime Minister would make a great difference to all those who were told the natural function of their body was a shameful thing. Simply by apologising, she would send a message to anyone unexpectedly pregnant today that they ought to expect help and support and never probation. So this is where I think there's a bit more ambiguity, because what I wouldn't want to say is that because I've only looked at files that are open, because I've only looked at ones where the kind of closure periods exist, and because also the lack of information about adoptees consciously within historical records, it would be misleading to then say that with the change in the acts, that period came to a clear, demarcated end. That would not be reflected by the historical evidence that's available. And looking at underlying continuities in adoption practice, the purposes, but also I would then say beyond the records, and this is, I know, what the purpose of the rest of many of the events are about, the long-term impacts and consequences, intended or otherwise, of these processes over time, that needs surfacing and articulating. And I think that's very, very important. And having this as a forum in which to do so, conscious in the view that the lived experiences are kind of repeated, almost the kind of the truth of those in the existing archives, that should be the point of exploring this further. That it shouldn't be an end, it should be the end of the beginning, getting over the line to then rethink about any kind of enduring continuities that are then shaping practice and understanding and ideals and the purposes of adoption from a historical period of time when it's kind of an exponential basis right the way through to the present day. I'll stop there.
Thank you very much, Mike. That was amazing. You've guided us through a very complex area, and I think probably introduced a whole series of things to some of us and who haven't come across so many of these facts before, that you've been busy unearthing. And thank you for acknowledging the value of our lived experience. I noticed one question in the chat asking about Northern Ireland, and wondered if you had anything to say to that. If any of your research has extended to the mother and baby institutions in Northern Ireland,
Yes and no. So no is probably the first thing, in that there's been a separate or ongoing inquiry or process of research and inquiry into Northern Ireland, just trying to unearth a lot of this. And just as in the case there were for England and Wales and Scotland, there are a whole separate series of files for Northern Ireland that kind of cover this period. So people are trying to examine those. But there's a kind of a further layer, in the sense that the Scottish and Welsh dynamics within England administrative policy, they still kind of fall within Westminster because of the political situation, the changing political situation in Northern Ireland. It's a bit more complicated because there's still formal accountability in Stormont until 1969. So that is kind of separate from England and Wales until direct rule takes over. But again, don't let that mislead you, because just as there are exchanges between England and Wales and Scotland in terms of the files, there's also exchanges with Northern Ireland, showing that there's enough resonance. Now, the Northern Irish dynamic in terms of policy is far more obviously accentuated to the religious dynamics and making sure there's adequate, appropriate provision as well. And you can see that from the kind of similar files in Scotland. But I know less about it because I've not had a chance to go through the files in Northern Ireland, because that's ultimately where I think you'll get a lot of the evidence about it, but also because there is a formal inquiry process in that. Even those files, they're kind of being taken away in the short term, so people can then have a look through them. But hopefully, you only find out with benefits of hindsight, but they're looking at all of the relevant files. And in my experience, the tedious financial administrative oversight files are far more revealing than the ones that are talking about the kind of really due process in law, because they reveal what's actually happening. So take the same thing that I'm doing to Northern Ireland, just apply it there. You just need access to those to paperwork as well.
Thank you. And has any of the other panelists spotted questions in the chat that you can
I have a question. I always have a question. I have a question. Yeah, I do have one, and it's a personal one. I think for Scotland, and I know that you had you did quite a bit within the Scottish Chapters Inquiry, and I know you touched on it a little bit there. I'm wondering if you could maybe go into that a little bit more and just say a little bit about how you found doing that and that link with adoption. The Scottish Child Abuse Inquiry, and there obviously has been an inquiry in England, and adoptees, and we are not by any means the only ones who are a gap within this inquiry, but we are one of the ones that are a gap within this inquiry. And I'm wondering how you feel about that, and because obviously you have looked at the historical records. So yeah, that's my question, because I know there's people here from the inquiry, victims and survivors, who I'm sure would be keen to hear those things.
Yeah, to ask the most kind of pointed question, because I'd say that my view on this has changed quite a lot in conversations that we've had about it effectively. That I can see why, again, in terms of that narrow legalism, that the Scottish Child Abuse Inquiry has taken the decision it has to not include adoptees, because it's effectively saying that at that time it's a managed relationship. That the key thing here is that during this kind of classic period, so from the 40s through to the 80s, well, late 70s, early 80s, is that it's not a direct child welfare measure. So children aren't formally going from the care of their birth parent, birth mother, into local authority care, that you recognise kind of this care experience, this children in care dynamic, and then the adoptive family. So that is what happens as a result of changes in the legislation later on, because the supply, the commas, of babies dries up with access to abortion, access to reproductive control over women's health, effectively in the 1970s, pill and abortion, and the fact they can become accessible just transforms what adoption societies do. But during this period of time, because the state's argument is that it's a managed relationship, so even though it's overseen, even though it's funded, even though it's managed, and kind of the limits of what's acceptable and what's not, is still, from all the files that I've shown, it's still managed by the state. I think it's a bit of a cop-out almost to then say we're not going to look into this issue, because I think it speaks volumes about the gap in the record that I've talked about and have become far more alive in conversations that we've had, that because the idea was that you've gone into this new family, it's a perfect union compared to the kind of pathological one that was there before, we shouldn't be interfering, we shouldn't get involved, we shouldn't be kind of routinely visiting, because that would be disruptive almost. And then that means that if there is any abuse or harm, and clearly from what's going to really come to light, that is taking place, the fact that that's not something being consciously investigated at that time, the time to time clause almost, is something that really does warrant attention, and it should be an opportunity to then both validate and legitimate those lived experiences and say, look, you can't avoid this as a result of this kind of technical legal relationship. It's still consciously managed by the state, the interest of the state. Understanding that, yeah, I'm happy to do all the legwork on that, but that then I think opens the door to it. So again, it's slightly different in terms of the child migration because there was a much more formal architecture in place. But I think you're absolutely right. I think that does need revisiting in light of the fact that we know about the extent of state involvement and complicity.
Yeah, no, thank you. That was my question, because I know that other people would want to. So I'll leave the floor for the rest of the panel at the moment.
That was a telling phrase, the from time to time. It was one of the things that stood out and stuck with me. I see there's a hand up in the panel. Dawn, do you have a question? You just need to unmute.
Thank you. Thanks, Michael. And it's really nice to see you in real life, because you helped me when I posted a random post on Twitter, as that's how things come about. Sorry, I've got a dog here. Hang on. Right, just got rid of the dog. The amount of what you said, try to distance, and I have always distanced myself, and I do distance myself because we as a group, we have to distance ourselves from what our own stories are. But the amount that was in there, that is like word for word, that there were lines word for word that are on my own record, and you personally gave me more information that I waited and I'd searched, and believe me, I have searched like any other, who does searching, and you cannot find, and you just lose trace, you lose the scent, and you've got no idea. There's so many false dates, there's so many false names. It's like it was almost set up to fail in order to fail. And if you were able to read the comments, everybody is just saying thank you, and that it was such a great presentation, and how much information and how much state involvement. Well, it is state funded, and it's as simple as. We knew that, but thank you. That was difficult to listen to, but thank you so much, and I hope you read the comments. Thank you.
No, thank you.
Michael, I'm just going to touch up. There's somebody has come in and asked the reason for this research, and I know that you kind of said it at the beginning, but it would be nice to kind of hear. Was it something that what kind of pushed you in this direction, or was it something that you've just fallen? I know myself, I've just fallen here, so so just in case it was missed by the person, even though we caught you at the beginning.
So I mean, for a public consumption, and whenever the government would be asking and larger expert audiences, I will say obviously that it's my plan all along to look at what I've done and the way that I've done it, but realistically, what happened was that I was given access as part of the PhD that I was funded on to look at these closed social work case files. Now, I came from a background of working in the local authority housing and homelessness service, so I was kind of familiar with a lot of those dynamics. But trying to reconstruct the welfare state from the kind of official documents and what I was reading, it was miles apart. And so, in a very long kind of mundane way, the only way I could understand the decisions that were being taken about individual children and families was to kind of just go out into this huge welfare state architecture, effectively. It was inescapable, because trying to understand how such really harmful decisions were being taken systematically, and again by social workers, normally I would say, having taught social work students, they're very progressive people, they're very kind of righteous people by and large. They don't get into social work because they want to harm people. They want to do it for the right reasons. It's not about the money. Good Lord, it's not about the money. That's why they get involved. And then how on earth could people who are doing that time and again, systematically, over a long period of time, produce such harmful and damaging outcomes and completely unreflective? And it's trying to understand that process that I was then reconstructing how the welfare state worked effectively, because it was about linking those really damaging experiences that people had in interaction that are really common across the inquiry and kind of been written about, and saying that there's a reason that they're common is because it's related to how the practice is taking place and what they're for. And so trying to take that conversation out from, someone knocking on a door in Aberdeen in the middle of the night in the 1960s to a decision being taken in the 1940s by civil servants over dinner. That's the link that I'm trying to draw out here. So although I'm not directly concerned with adoption of unmarried mothers, in trying to reconstruct the whole parameters of the welfare state, it was in the subject of my files that I was looking at effectively, and it was wrong to not explore that element as part of it. I was trying to pursue every end to see what was taking place, and it was such a big bit of it that it had to be pursued. So I hope that kind of answers the question. It's unintentional, but it was just in trying to rebuild this understanding of how the welfare state actually works that I kind of came across it.
Thank you, Michael. Thank you. And Sarah, have you got a question?
Yeah, just one. It's interesting how you're talking about the correlation between Aberdeen and somewhere else. And it sort of lands in nicely to the question that I want to ask you, actually, in terms of like your research, like what would you like to see change between state and local government regarding policy and legislation?
I mean, that's a big question. A lot, I think, is the answer. So it's kind of, for me, take it back to what I see as one of the root problems and causes. So the reason that families, and the research I was doing in the 1940s, and I say there's tremendous continuity through to the present, is the reason they're coming to the attention of the local authorities is because they were in poverty, in very difficult economic sets of circumstances. And the idea that you can improve a child's future by rescuing them from that environment, lifting them up and taking them to another environment, that's got a very strong continuity in how the state operates. Going right back to the NSPCC, the 1880s, how they operated, the inspectors, parents are neglectful, they're harmful. And ultimately, while they focus on these accounts of physical abuse in their written work, going through the NSPCC case files, like anything else, it's overwhelmingly poverty they're dealing with. And I found that it's inescapable in terms of the paperwork that I was looking at. And when you look at the same principles being applied today, the idea, particularly under the Conservative government, about child rescuing and about early intervention as early as possible to remove children from harmful parents and circumstances, I find that strand of continuity incredibly problematic, because what's stopping the support being offered or kind of help or authorities working in that way? And part of the reason of understanding the welfare state architecture is because no single authority is responsible for poverty. And that's a lot of time why I end up arguing with who's paying for what. And I think talking about that is significant. And I think that as an underlying historical bit that I can speak to the past to the present, it needs surfacing.
That's a wonderful answer, Michael. Thank you. And Dr. Josie has a question, and I think after that one we'll have a little break and we'll get our lunch on. But Dr. Josie next.
Thank you. I love being called doctor, as you might have gathered. Thank you so much, Michael, for such an illuminating journey through those papers. The period that I got really interested in when I was doing a creative PhD was creative writing PhD was the 20s, and the reflection. There's so many echoes with the attitudes in the 1940s to those in the 20s. This, as you say, this whole thing of, in fact, I read out a quote earlier from somebody who just, as we all know, poor people can't take care of children. They have so many children. We need them. And something recently that I've been more aware of is that there was a lot of infertility after war because people came back with venereal disease. I'm very interested in the way that it gets transferred to the women when in fact it's the men that come back with it and cause the women to be labelled infertile, the adopting women. Anyway, I have to keep telling myself to calm down. So I was really interested, and you also, I think, provided an answer for me about a little piece of evidence that I need to look at the history of one of the societies, the National Adoption Society. And it is so hard to find records of I want to know who the different chairs of the society were, and it's just so hard to find the records. So I will probably ask you how to do that, but I don't have to do that now. But I just really appreciate what you're doing for the adoption apology movement. It's close to my heart. Thank you.
No, thank you. And I'd say in terms of the standing on the shoulders of others, one of the best books that I've ever read on that kind of transformative period, you're probably familiar with itself, but others might not be, is a book by Jenny Keating called The Child for Keeps. It's absolutely fantastic in understanding about how adoption became legislated in 26, and then that particular window of almost failure, but their influential lobbying to very senior elites and religious voluntary organizations that resulted in both that circular that I mentioned in 43 and then the 49 Act. So she kind of provides the preamble to what I'm doing. It's a fantastic book. I'd really recommend it.
Yeah, thank you.
Not a question, but just a bit of feedback. The word that popped into my mind and then it seemed to pop into the chat at much the same time was we find your work very enlightening. So high compliment. Well done. Thank you.
Thank you. I really appreciate the opportunity to share it and kind of to have it of some value as well. That it's not just, this kind of boring technocratic history. It shapes the circumstances of so many people's lives.